Good afternoon, everybody. My name is Rhiannon Gogh. I'm a chartered financial advisor, and I'm delighted to be here today talking to you about the transition to adulthood, so financial planning for post-18. So I'm the director of PlanIt Future Financial Limited, and I'll tell you a little bit more about us and what we do in a second, but it's a real pleasure to be here talking to you today. So PlanIt Future Financial, we are an appointed representative of a company called St James Place. That's a large firm of financial advisors. There is more information available about St James Place on the website there if you'd like to go on and have a look at that. And just that brings me on to a very important point. Don't feel like you need to scribble things down, addresses and such. If you don't want to, the session is going to be recorded, but also we're going to be sending out the slides after this presentation, and there will be a link to the recording probably within about a week or so after this session, I would imagine. I've just put up a contact housekeeping slide as well. So yeah, the session will be recorded. There is some time for questions and answers at the end. You can, if you've got a furiously important question, you can type that into the chat box, and those questions are being monitored. It would be ever so helpful if you could keep yourself muted just to help minimize background noises. And then there is a survey at the end. Do complete it. That comes from Contact. It's not from me, but yeah, there's a survey at the end. And we would all be very grateful if you could complete that and just let us know how the session went. Okay. So the agenda and the aims today. I know many of you, I think I'm looking at some of the cameras of the pictures over there, and I can see some familiar faces, but there are plenty that I don't know. So I'll tell you a little bit about PlanIt Future and what we do. We're then going to look at how and when we need to start planning for post-18 finances. We'll be looking at decision making and mental capacity. So how do we help people make decisions, and what bearing does mental capacity have on that? We'll be looking at managing bank accounts and how we do that. So how do we help someone with their banking and help them manage their accounts? And then we'll be moving on to living arrangements. So what impact does the living arrangement of a young adult with additional needs, what do we need to plan? What do we need to keep in mind for that? Lots of media interest in child trust funds. So we'll be talking a little bit about child trust funds and thoughtful saving. So just what do I need to consider when I'm starting to think about savings for a child with additional needs? And then summarizing and keeping it down to 5 points. So we'll be thinking about this. What are the most important points from today? And then lastly, the resource pack. So a resource pack is going to be, where do I get further information? How do I get help going forward? Okay. So housekeeping from me. So for those that don't know me, I'm a parent of a child with, a young man with autism. He's has complex autism. He's 13 years old. His name is Tristan. You will hear his name today. I apologize because I tend to talk from my own experiences, but today's talk will be very much from one parent to another, from me to you. It's usually around 45 minutes, and then we have some time for questions. There is a resource pack at the end. It's aimed at a wide audience, and that means that within this presentation today, or watching this presentation, will be parents of different carers of different situations, looking after children of different needs and different vulnerabilities on a whole scale, and very broad. So today I will try to keep it as broad as possible, and bear in mind that what's right for my child might not be right for your child. So try to cover lots of different bases. If you need to visit my website, the details are there. There's a contact button. There's some lovely case studies of parents that we've helped. I also run Eventbrite courses on my Eventbrite page that sort of goes deeper into wills and trusts and so on. And then lastly, we're not giving legal or financial advice today. We're just talking on giving guidance and talking about the issues. And I think ultimately we're prepping parents for decisions that they need to make and thoughts that they need to have before they're thrust into the middle of it in good time. Okay. So about my business, so I'm a chartered financial planner. I'm a fellow of the Personal Finance Society. I have been in the profession for 22 years. Like I said, I have a son, Tristan, and my work with the National Network of Parent Carer Forums, I've been doing training sessions like this for about 6 years, and it's really all based on my own story. My own story is that when I became a chartered financial advisor, I soon realized that the plans that I put in place for our family were not quite right. There was a lot of work that I needed to do around wills and trusts and getting my own house in order, so that when I was no longer here, I had put in place plans to protect Tristan, but also that I had the mechanisms to help him throughout his life. So that's the story and the methods and the plans that I share with other parents. And I've been doing that for about 6 years. I am a special needs financial planner. So that means that I am a financial advisor with a knowledge of benefits and the general financial issues that parents tend to face, because I face them too. I've created an advice pathway for parent carers. I'm the chair of governors for a special school, and I do lots of presentations like this to charities and special schools and such. So that's who I am and why I'm talking to you today. We offer many online courses and webinars. These are the ones we've got available at the moment, and the most popular of those is definitely wills and trusts for special needs. But generally speaking, we're there to inform and educate and advise. And the inform and educate bit is incredibly important, because no matter how many times I do presentations like this, and I'll go out and I'll talk to parent groups or special schools or whatever it is, there is whatever I say seems to be a complete shock to people. It seems to be new information, or it seems to help parents just lift the fog and they can go off and start planning. It seems to be so needed, this information. And my goal really is to give out information to educate parents and carers so they can make the decisions themselves, and when they need advice they can come to us. So that's what we do, and there's more information on what we do and the webinars that we run there. Okay, so we have talked about who I am and what I do. Good opportunity now to look very basically about the key financial touch points from being born up to being financially independent. And these are generic. And it's like a financial timeline, financial planning timeline. So you start with being a baby and parents are funding everything, and then you might have relatives starting to save. You're going to school when you're 5 and you've got pocket money potentially if you're lucky enough. You may even have your own bank account when you get to sort of 11-ish. And then we move on to saving for exciting things like cars and homes, leaving home, moving out, bills, loans, not so exciting, and then work, pensions, and really financial foundation building. So when we're looking at how and when to plan for post-18 finances, these are those key financial pinch points, if you like. So this is a special needs child to adult financial timeline that I've put together. And you can see there's a lot more going on. So when we get the beginning of the journey, that we potentially might have the diagnosis of some kind of additional need, or an understanding that there is an additional need there. We might have a support package if we're lucky enough. We might have that support. We're moving into schooling and understanding what needs there are. We might have the EHCP. And that dotted pink line there, that transition from pre-post going to 18 is often a real shock for parents of children like ours, and a real time where things just seem to happen and parents have to all of a sudden, and carers have to all of a sudden navigate this world of financial decision making. And then there's a transition to adult services, and then we've got potentially benefits in our own name. We've got access to savings. We know with, for example, child trust funds, we're assumed to have the mental capacity and the parental responsibility that we have, that I would take for granted. Of course I can make decisions for Tristan, that would stop. So there is a real cut-off, and in my experience, a real shock for parents, for some parents in that position. And then you move forward and you think, for example, about supported living and residential care, and all these questions that are thrown up around the living arrangements and the funding of that, and where they're going to live. So there are definite points that we need to think about, but the key one is what happens at 18. And I often find that's quite a rude shock. So you have the fact that at 18, a child becomes an adult, and you no longer have the right to make decisions for them. So that parental responsibility stops. And if I want now to make decisions for my son, I have to have some kind of tool to help make decisions with him, for him, and so on. And so there are two routes that we can look at, that we can use to help make decisions and to help with financial decision making. And they very much depend on mental capacity. And we'll talk about those in a second. But ultimately, what we're aiming for and what we're trying to do is we're trying to make our young adults well-prepared adults, have them potentially live independently where they can, and be in employment or have meaningful employment. And in order to do that, we need to start thinking about how we help them make decisions and just understand which tools we can use and can't. And I would say there's a little bit in a speech bubble there about approaching adulthood. And you have to, I've come up with a certain age, because it's very difficult when you have a child, especially I know with Tristan when he was diagnosed, it's very difficult clearly to say, right, okay, you've just been diagnosed, that's definitely going to happen, you're definitely going to follow that path, that's what the future looks like for you. I don't know what the future looks like for Tristan, or I certainly didn't then, but as he's growing, I can see I'm getting more of a, oh, okay, we're possibly going down that path. I've got conversations going on with the school. We know we have the year 9 transition discussions and different fairs that we're starting to get invited to, and it's becoming clearer what I need to start planning for. So I would say, when parents ask me, when do I start planning for post 18, I would say probably around 15, 16-ish is when we want to start thinking about that. And there are certain cues, there are certain things that we need to consider. And when I think about all the presentations that I do and the questions that I'm asked and the scenarios that are posed to me because of parents that weren't potentially aware of some of the issues and have found themselves in really difficult positions and need help, it usually comes down to one of these 4 areas. So the first one is around decision making. So how do I help someone make decisions? How do I help them access bank accounts? How do I help them? What can we do? What can I do? How can I help, and how can I not help? And what do I need to do? Secondly, living situation. Now that we're at 15, 16, we might 17 have an idea about the living situation, and that will have an impact on the type of planning we put in place. So I know if my youngster is going through residential, potentially, if they're in residential already at 15, 16, I might be needing to think about, again, what decisions I make. If I know they might be heading towards some kind of supported living, how is that funded? Is that means tested? Do I need to bear that in mind? So lots of planning and thoughts to consider around that. And then thirdly, a huge part of planning for the future is protecting assets. And it's a funny word, assets, but assets generally mean as Tristan gets older, I have to think about what happens when I'm no longer here. And I have to consider whatever I leave behind for him. I have to consider A, is he going to be able to access that? So who's going to be able to help him access it? B, is he going to be vulnerable? I won't be there. So how do I protect against that vulnerability? Do I use trusts? Do I have people there to protect him? And C, if he's in receipt of means-tested care and support, what impact will what I leave have on that? So planning around protecting assets. And then the fourth thing I want to start thinking about is the team. So who am I leaving potentially behind, or who have we got as a support network for Tristan? So who am I leaving behind? Am I leaving behind guardians or deputies or trustees? Who can protect him, and who's there for Act 2? So those, without sort of going too deeply into it, those are the 4 key areas that we need to start thinking of when we're planning for the future. Today, we're going to be tackling decision making and a little bit of living situation, but putting it into context, I think, is important. And I would say, to summarize when to start planning, 15, 16 great times to start thinking about this. Okay, so let's move on. So we've talked about what things we need to consider, what might be happening at age 18. So we now need to think, right, okay, so I'm 16, 17, or maybe I've got someone that's 18, 19, and they need help with their decision making. What do I need to do? So there are 2 steps that we need to take. And the step 1 is we need to work out mental capacity, work out, establish, assess. We need to bear in mind, is this person able to make their own decisions? Does this person have the capacity, the ability to understand information, retain and remember it, and act upon it? That's what we're looking at. And there are 5 general principles that we follow. So we have to start with the assumption that they do. So we start with the assumption they have mental capacity, and that we would take all steps to help with decision making. So what does that mean? So it means that with my son, I would imagine that would mean social stories, and it would mean PECs. Sorry to use, I'm sure you know what I mean when I say PECs, but it would mean visual aids, without using jargon. And it would mean lots of visual aids to explain the different outcomes of different decisions. I would be taking all kinds of steps with him, and they would probably look like that. And then I have to bear in mind that because Tristan makes unwise decisions, that doesn't mean he lacks capacity. So I can't use this, I can't stop him from making unwise decisions. Doesn't mean that he lacks capacity because he's making the wrong decision in my mind. It means that he's potentially making unwise decisions, but not because maybe he lacks the capacity to do so. And then once I have looked at those, if there is the lack of capacity, that I feel there is a lack of capacity, I have to ensure that any decisions I make for him, with him, whatever, are in his best interests, and that we choose the least restrictive option. So I look at the options I've got available, and I choose the one that least interferes with his freedoms and his rights. So those are the principles of mental capacity. And that's what we're looking at determining. Does this person have the capacity to make the decision, or do they not have the capacity to make a decision? Now, once we have established that to the best of our abilities, we move on to stage 2, so step 2. So we can choose the route. So using my own example, I would say, okay, Tristan, yep, we've got the mental capacity. There are tools that I can use. There are visual aids that will help him make his decision. And I then have options. I can support him to make decisions. So, and again, there are many people on the call with different situations. And there might be some that can make decisions, but they need support. They need understanding behind it. But once you've given them that, they're fine to make their own decisions. So you could just simply say, I'll support you making your own decisions. Great, okay. There's a third-party mandate. So now we're looking at banking. And we could potentially say, you know what, I will use what's called a third-party mandate, which means that I can look at your bank account. You give me permission, and I will look at your bank account, and I will help you by carrying out everyday banking. I might obtain information, I might make payments, but it will all be done with your permission, with me just looking at the bank account. And how I do that, as a sort of as a sideline, if you want to do that, you would go to the bank and say, right, we would like a third-party mandate for me to look at this account. So you have to have their permission, but that's absolutely possible. You can do that. And some banks are very, very open to that. Some have restrictions, so you might be able to have a third-party mandate for, say, 12 months. But it's possible. Need the mental capacity of the person to give consent to that. Or we could just simply have bank tracking apps together. So I could maybe share with Tristan, we could look at his, we could download a bank tracking app and we could look at it and we could talk about it and I could help him manage that way. Or we could go down the legal route, which is by lasting power of attorney. So lasting power of attorney is Tristan, come 18, would say to me, right, I need help with my financial decisions and I would like you to help me with them. And he would fill out a power of attorney form that we would get signed, and we would enact a power of attorney where I could help him with his decision making. I could do it on his behalf if he wasn't there, and I would help him. I could make decisions with him, but that would be the legal route to use if Tristan had the mental capacity. Without the mental capacity, there's the option of what's called deputyship. So conversely, if there is nothing I can do, very little I can do to help Tristan make a decision, then I would go down the route of deputyship. And you might be aware, but I'll really explain what deputyship is. Deputyship is when I would apply to take over control of his financial affairs because he doesn't have the capacity to do it himself. And I could do that in the run-up to him being 18, so that when he's 18, it's ready and it's there. And I can do that on 2 different counts. I can make financial decisions for him under this order, if I get it, and we'll talk about that in a second, or I could potentially make welfare decisions for him, so personal welfare. We're talking today about financial decisions. So if I wanted, for example, to help him with this bank account, and even to open an account for him, and he didn't have the capacity to do that, then I would be taking out what's called a deputyship. And so I would be filling out forms, and I would be sending off my application, and I would to the Court of Protection, and I'd be waiting to see if I was successful in receiving that deputyship order. I can see, I can see a few questions coming through. Do we want to stop for a few questions, or would you like me just to carry on? I don't mind clarifying a few things.
Go through the questions because there's only, I think, about
yes,
3
please.
or 4. So the first one is, would a joint bank account, be a viable situation to help a young person?
That's a really good question. So let's not forget, with a joint account, we jointly own the account. So we are both owners of the account. So absolutely. Also with a joint account, you'd have to be careful if there wasn't the mental capacity to do that. So you wouldn't be able to open an account for somebody that doesn't have the mental capacity. You also might fall into a situation where the person did have the capacity, then doesn't have it. And then you might find banking difficult in a joint account where one doesn't have the capacity. But it is, if you have joint funds, it is an option, yes.
And the other one is the deputyship. Can it be done once the young person is over 18?
Absolutely, it can be. It really can be done once the young person is over 18. So I think it would be wise, if you felt that you definitely needed that, you might be wise to start it sooner. And there's a little bit in the presentation about that in a second. But yes, you could do that after 18. You don't have to do it before or on. It's something that you could do. And to be fair, we'll talk a little bit about appointeeship and the difference between that in a second, which might be helpful in that scenario.
Yeah, I mean, there's kind of another question connected to that. I mean, how soon can you start the deputyship? Can you start it when they were 17? But I think you've kind of answered that.
That's a very good question, because we have to remember that deputyship, and if we skip there, so deputyship can take several months to put in place. And so I'll move ahead with the presentation now, if that's okay, Cindy, but deputyship can take several months to put in place. So the smart idea there would be thinking, right, okay, we've just turned 17 potentially, and I know that that's going to take some time, then I might want to start that so that when we get to 18, we don't have the delay there, and that's quite acceptable to do that, absolutely. So yeah, so when we look at lasting power of attorney or deputyship, the key thing to remember is that one is for those with capacity and one isn't. And when we have the lasting power of attorney, it's so much more collaborative. It is Tristan saying, Mum, in his own way, Mum, I need help. I'm choosing you to help me. Deputyship, very different. Deputyship, you going to the court saying, I'm taking over. I'm taking control. I'd like to take control of that person's affairs. And the court saying, okay, yeah, we've looked at that. Yes, you can on this basis. Very different. And so lasting power of attorney from age 18, deputyship can be before age 18, or as somebody very rightly says, it can be after that. There are different levels of supervision with deputyship. So there potentially would be annual fees and annual reporting duties that you'd need to carry out. The costs are different, but there is help with fees available, and the process is longer with deputyship. So there's great differences there. And that was a really good question that somebody asked about being post 18 and having deputyship, because what we sometimes think, there are definitely only two routes that you can use, and that's lasting power of attorney and deputyship, but we do have appointees as well, and I'm sure that's a phrase everybody knows on this call. I'm Tristan's appointee, and an appointee is somebody that deals with benefits. And it deals with benefits. What does that mean? It means you make the claim for the person. So I, as Tristan's mum, will be made a claim for his benefits. I will receive the benefits in my own account, and I'll be spending the benefits in what I feel is their best interests. So that's the role of an appointee, but it doesn't entitle you to, for example, have access to their bank account, go off and do banking for them. It's very finite, but it would be sensible to think at this point, okay, well, if the decisions that I want to make for my young person or want to help my young person make, if it's only benefits, if their only source of financial decision is what to do with the benefits, well, I can quite happily carry that out as an appointee. But when their life moves on, and then we talk about supported living and potentially tenancy agreements and bills and loans, I could then say, right, okay, I need a greater level of to be able to help them in a greater level, then I would go on to deputyship or lasting power of attorney potentially afterwards. So those are the routes available. Okay. So when we're looking at managing and using bank accounts for somebody, we now know, and we're clear on the fact that we have to really think about the mental capacity, and we would follow those two routes. We know that an appointee can't look at a bank account, and we know that parental automatic rights stops once we get to 18. But banking and having your own account is nevertheless, I think, important when it comes to potentially employment and bills and independent. It's almost a basic human right to have a bank account. Thinking back to that well-prepared adulthood, having a bank account is principal in, I think, in starting an independent or having an independent life. And when we come to set up bank accounts, there are reasonable adjustments that you can request that a bank would make for you and your loved one. So that would be a quiet space potentially, appointments, not queues. I'd like to come in to open an account. I have a young man who is autistic. This would be me. I have a young man who is autistic. He's going to be struggling in this scenario. I would like I would like some reasonable adjustments, please. And I would like potentially a quiet space, and I would like somewhere, a time that we can talk about it, that I've got time to explain to him rather than stood in the queue. That would be helpful. And there are definitely differences in approach that I have noticed. And I was only yesterday helping a client navigate something bank-wise, and there is a difference in different banks and their behaviours. So I would absolutely be shopping around. Okay. What decisions can you make? So let's say you have determined this mental capacity. You know which of these tools that you want to use, and what can you do? So this slide just talks through the differences and where a third-party mandate wouldn't work. So you know that with a third-party mandate, you could potentially do everyday banking, but you won't be able to do things like signing tenancy or mortgage agreements. With a third-party mandate, you'd need something you'd need to have that deputyship or that power of attorney. Okay, so we have talked about decision-making, a little bit on child trust funds, and they have been in the media a lot recently. So we know now that we can't access a child trust fund, or we, generally speaking, can't with an appointeeship. We need potentially a lasting power of attorney or a deputyship if the person is struggling to access their child trust fund or would have difficulty with that. There is a great guide that has come out very recently on child trust funds and accessing savings, which I've put in the resource pack. But we need to consider exactly those two routes. So what do we use and when do we start that? So if we know, for example, that we're going to require deputyship and we're going to require it at this time, we could start that early so that we can access that child trust fund potentially. And there would be help with fees as well. So if the child trust fund is the only asset usually that you're trying to access with a deputyship order, and this is the person that the child trust fund belongs to, has less than a certain level of savings, then you can claim for help with the fees for that deputyship arrangement. And again, I've put details of those in the resource pack. Okay. Right, so we're doing a little bit of a handbrake turn now. We're going into living arrangements. We've talked about how to access bank accounts, how to make decisions. The next sort of 5 or so minutes, it would be worth thinking about living arrangements and residential care.
Can I just ask a question?
Yes, certainly.
With the lasting power of attorney and the deputyship, how long do they last? So you have to reapply.
Okay, so that's a really good question. So the lasting power of attorney will last until the person that's taken it out. So if it was me and Tristan, it would last until Tristan says, I don't want you to do that anymore, I'm stopping it. Or if Tristan loses capacity, the lasting power of attorney would then change and I would be able to use that for him. So generally speaking, with the lasting power of attorney, it would go on until Tristan revokes it and stops it. With the deputyship, that really depends on the scope of the deputyship that you were given. Sometimes a deputyship arrangement is given for a one-off circumstance, and sometimes it's given on almost like a rolling basis, and it's generally looked at on a rolling basis to see if it's still needed. So I hope that answers that question.
Thank you.
Okay. Any more questions before we move on to living arrangements, or shall I crack on? Right, I'm good. Oh.
Hello. Sorry.
Hello.
Is it okay if I ask a question? Yeah. So, if capacity, does it have to be just a parent doing it with PECs, or does certain places or industries or anything actually want medical proof that capacity is there?
Yes. So when you take out either a lasting power of attorney or a deputyship, there is a part within those applications that will almost like a check that there is the capacity or not. With the lasting power of attorney, there is somebody that signs that document to say that they're called a certificate provider. And that is someone that signs to say that the person is not it understands what they're doing. So it's a very, very brief. Tristan is not being coerced. Tristan knows what he's doing. I can certify to that. Very, very straightforward under lasting power of attorney. Under a deputyship arrangement, it's different. So when you apply for a deputyship, there are forms that you have to fill in for different parts of the forms, and one of those is mental capacity. Is like a mental capacity assessment, if you like, and that's evidence that you are providing, or that's being provided, that will say that that person doesn't have the capacity. And if you're in a residential care home, quite often they would do that part of the application if they're carrying that out. A GP could do that, potentially a social worker could do that. Somebody that is in a position to be able to, apart from you, to be able to attest to the fact that person hasn't got mental capacity. In experience, it's usually the GP, social worker, someone like that would fill that part in.
Thank you very much.
Very welcome.
Did you want to take any from the chat, or do you want to leave those to the end?
Should we do 2 minutes from the chat, just a quick one, and then I'll before, because we're moving on to a different subject. So
I think you've answered some of the questions already around how do you establish mental capacity in regards to maybe you need to speak to somebody who does that mental capacity test. There was a chat about annual fees or setting up fees for a deputyship. Is there any fees in costing to be aware of in regards to setting up deputyship?
there are costs to be aware of. And I've got, at the end of the presentation, I've got a link to the fees part of the deputyship application. Absolutely. I think the important point there is to think, and really from speaking to parents, is to think, what do I need this deputyship for? And if, like I said, if it's just things like benefits, or if there's very little money there that you need to manage, then you'd have to be pragmatic and think, is it worth doing the deputyship arrangement for what I'm trying to manage? Could I do that via a third-party mandate, or not a third-party mandate, via some kind of other arrangement? Appointeeship springs to mind. So, but yes, there are fees, and I can certainly share those at the end of the presentation.
Supported living tenancy agreements without a deputyship. How does a person lacking mental capacity do this? They've said they know a few LAs. Our LA has dealt with this for several people I know without there being a deputyship. So supported living tenancy agreement, is it best idea to have deputyship? Or
so generally speaking, when you're taking out supported living, or when you're going through supported living, it's usually the person taking out a tenancy in their own name, generally speaking. In that case, there would need to be some kind of, if there isn't the capacity to do so, there would usually need to be somebody there to sign a tenancy agreement for them, and that would usually be a deputyship. Absolutely. But my point there would be, there might be cases that the local authority would have some kind of mechanism for enabling that not to happen, but my thought would be, do you think you still need to help them make financial decisions in the future with potentially bills or things like that? And if the answer to that is yes, I would very strongly consider deputyship, regardless of whether it was asked for or not, if that makes sense.
And the last one I have, if the young person's still living at home, how will this affect my benefits as I'm on universal credit? He does get PIP, he's 17.
How does it affect it? I'm not sure what the question, so how does, once they turn 18, how do perhaps the benefits they receive impact the benefits that person? Perhaps I could answer that offline with that person and pick that up, just so I can understand the question that I'm answering. No problem at all. So let's move on to living arrangements. We've spoken actually about living arrangements already a little bit. There are some really important planning points that are often missed when it comes to living arrangements and residential care. And there are some points that we need to consider, and that those are, for example, the different shapes and sources of funding. So there will be those within residential care that have care that is funded by the local authority, and those that have care that is funded by the NHS or continuing healthcare, and so on. So there are different shapes and sources of funding to consider. There's also, when you get to supported living, generally speaking, you are there and expected to furnish or to provide the furnishing for a house also. So I know that comes as quite a shock to parents when they embark on the supported living route and realise that usually it's down to them to have to furnish the property. And it does make me think about Tristan and furnishing a property for him, and it would have to be sturdy and strong furniture, certainly, to be able to cope with the rigours of what Tristan can put it through. So there is that to consider. Potentially you might lose a mobility car. If you have the mobility car and then somebody is moving into supported living, that mobility car may then go. And we want to consider the protection of whatever support and services that they are receiving. So the planning points, which we did really come to within those questions, is when we have that supported living residential care and we know the path that we're on, we need to then consider, right, what kind of decisions am I still going to need to make, and do I need to take out either a deputyship or a power of attorney? I also need to consider, as part of the bigger picture, what impact what I leave behind has on that living arrangement. So if I'm leaving behind assets that are going into a trust, if I'm leaving behind things that are being inherited directly, what impact does that have on the care that is being put in place? Have I thought about that, and have I protected that or put in place plans to minimize any potential disruption? And have I also thought about costs of furnishing supported living and what those might be, rather than, as I know, speaking to somebody last week, it just come as a complete and utter shock that they're now expected to pay to furnish a small house. So some very important questions around living arrangements that we start to think about once we get to post 18. And then coming on lastly, with perfect timing, to saving thoughtfully. So we've discussed decision making, how living arrangements impact how we plan for the future. The last thing we need to think about really is saving thoughtfully. And we have, going back to the timeline, throughout that journey from child to adult, there are usually points where somebody will say, oh, I'd love to save for this child, or I want to put some money aside for them, or I would like to make provision for them in my will. And we have to be very careful and thoughtful about that from exactly the standpoints that we've just discussed, the access. So what I'm planning, will that person have access to it? How will they be able to access it? Will they need one of the two routes to access this savings plan that we're going to put in place that will be theirs when they're 18? How are they going to access that? Who's going to be there to help them? Are they going to be vulnerable, susceptible to manipulation? Do I need to protect it in trust? Are family members, grandparents planning to leave money in a will? And if so, is that protected in the same way? And so we need to consider the savings plans, whether they'll be those that are going to be in their own name once they turn 18, how they access those, and then maybe even think about pensions as a possible savings vehicle, knowing that those are there for the long run. So for some people, they might not work, but that is a potential avenue as well. We have to be very thoughtful and consider all of these things we've discussed today when we're setting up savings plans, or when relatives do exactly the same. Okay, so that is enough, I think, on those areas. The summary and the top 5 points to take away from today, I would say when we get to 15, 16, we've got to plan in time to avoid this rude shock. So we've got to start thinking about post 18 when we get to 15 and 16. We have to consider mental capacity and using the two routes. We have to be thoughtful about living arrangements and what implicit costs there are within those. And we have to think about leaving wealth protected. And I put an asterisk on wealth. It doesn't have to be a lot of money left to somebody to potentially cause difficulties. So when we say leaving wealth protected, we really are talking about general, making sure that death in service schemes or life insurance policies and everything that you leave behind or that is left for a child when they become an adult is protected in the ways that we have discussed. And then lastly, we're thinking about the team. We're thinking about who will be there. So, for example, if I'm a deputyship, who potentially might be the next deputy if I'm no longer there? Who would be the trustees? Who might be guardians? Who is my team for Act 2? Okay, so we have the resource pack, which we will send out. I hope that was useful. I'm 45 minutes, so we've got some time to answer questions. How we work, so what we do, we're more than happy, and I am more than happy to run dedicated seminars for your carer forum if you would like me to, so we can go and do sessions for parents around wills and trusts and really go deeper into that, or any area that you find that you're getting a lot of questions about. For client inquiries, my details are there. My Eventbrite page is there. There are some great guides available now on financial decision making. A particularly brilliant guide is there, the first link, and we will send these slides out so that you've got them. Are there any questions that we'd like to go through, or anything that people would like me to bring in that I haven't discussed? Or
on the chat, we have, could a school teacher do the mental capacity questionnaire, as my GP doesn't know my daughter, and the social worker, it changes every 6 months.
yeah, absolutely. So I would definitely talk to them. Actually, not forgetting as well, we haven't talked about, there are companies out there that will do mental capacity assessments as well. So that's another route that you could go down, definitely. So you're looking for somebody that has, and you're absolutely right, you wouldn't want to go to your GP if they didn't have a real knowledge of the person that you're talking about. Solicitors as well, we haven't mentioned solicitors, but when you go down one of these two routes, you can do them on your own, or you can use the help of a solicitor to help you that would be able to help you with that as well. So obviously it's something that you pay a fee for when you go down that route, but you could use that as well if you wanted to, definitely.
What do you need to do if you want your young adult to stay at home and attend college or daycare? So you spoke about if they go into residential or supported living, but is it sort of similar situation if they actually stay at home?
So what do you need? So you would need to, my thoughts would be, I would be thinking, is that a permanent thing? And then I would be thinking, right, what decisions are they going to need my help with? And I'd be putting in place one of those two routes. If I thought they needed help with some kind of decisions, I'd be helping them via one of those two routes. And then going back to the first point, you'd be thinking, right, is that permanent? What does potentially, thinking about the future, would they stay at home? What arrangements have you made for them, or do you think they'll have in the future? And can you plan for that potential scenario with regard to decision making as well?
Yeah, and if the person somehow manages to save money from benefits, birthdays, Christmas gifts, for example, the savings then goes over the means testing limit. Will those benefits and any care contribution to resi care or supported living be affected?
So you have to, that's a really good point. And I hear this an awful lot, and it's something that I experience because it's very difficult to buy my son gifts and presents. There's rarely something that he actually wants that he can tell me about. So money tends to build up, is what I'm trying to say. And quite often parents tend to put their DLA money to one side. And you just have to be very, very mindful. It's exactly what we're talking about when we talk about living arrangements and that cutoff at 18. As soon as someone turns 18, then the savings that they have in their own name, of course, will be part of that assessment for means tested care. So they will impact potentially means tested care, and they will be brought into that assessment. So that is something that you need to be aware of that happens at 18, absolutely.
Before we
Can I
go
ask a question? Sorry.
just one more question and then I'll come to you, Kate. Is that okay?
Yeah, of course.
Yeah. One parent has just said, if I don't have a team, is there any other options, I suppose?
There is definitely, yeah, absolutely. Part of the wills and trust presentation that we do talks about putting together your team, and that is the most popular question that we have at that point is, if I don't have a team, who can help me? So there are the role of professional trustees and professional deputies, and that's an important point for that person to know, that there are organizations out there and roles that people on a professional basis can provide for you. And if you'd like to know more about that, we do talk about that within wills and trusts. But absolutely, there are people that could help you. Yes, I quite understand.
Okay, would we like to go to Kate for a question and then we'll go to Neil?
Thank you. It's a bit personal because my son was left money before he was born, so there was money for both of my children when they reached the age of 21, and you know, we don't know what his capacity is going to be. Is that are both the NHS funded and LA funded living arrangements means tested, and what options do we have?
No, so usually NHS care is not means tested, so, and usually local authority care is means tested usually, but that depends on the specific type of package that a person has. But generally speaking, that's the situation, and this is a really common issue because what's happened with I didn't know if it was your son, sorry, or your daughter.
My son.
Yeah, so what's happened with your son now, that's very difficult to unpick that, because it's already happened, and there's already what's called now a contingent trust, where at the age of 21 something definite is going to happen. It is probably too personal to go into on this forum, but if you'd like further help, then please get in touch with me and I can talk about some thoughts around that. But it is something that happens all the time, and it's one of those things that this is why planning for the future with regard to what happens family members wise, it's so hard sometimes to have that conversation, but it's such an important conversation to have, because it leads to issues like this. More than happy to pick that up with you separately if you'd like me to.
Yeah, thank you.
Did you still have a question?
Can you hear me?
Yes.
Okay, sorry, this is hard to know. Yeah, so I'm really interested. My son's 25 and he's going into, well, he's meant to be going into residential care, but the whole thing's been cocked up by the incompetent people and the really bad communication. Anyway, that's another story. And it's residential, but we're now having to consider supported living because there's literally no placements within a 20-mile radius of Brighton with a vacancy. So we're looking at, we've not sort of looked at the supported living, we're going to do that. And my question, I suppose, is around the resi care, is the care providers, which are predominantly private equity backed for-profit, businesses, they're penny pinching, trying to not provide things that they're meant to have allowed for in the, in response to the care plan brief that they got. And just a very, very quick example is that, we say that he needs shoes that are supportive of his ankles because he's got deformed feet, and they're not specialist shoes. Right, so the NHS can't use, but they're expensive quality shoes, and they're saying, well, he's got to pay for them himself, right? So on the one hand, well, might sound fair enough, but actually they're adapted, so they have insoles put in, for example. And another one is, for example, an annual pass to a local kind of sort of little theme parks, 40 quid a year for therapeutic and what have you purposes. And they're sort of arguing that. So the question is, how best can we ensure that the residential care provider is sort of somehow enforced to actually agree to what we believe are fair, reasonable, appropriate and relevant costs relating to his disability and therapy and clothing and what have you, things like that. Sleep suits, for example, he can't wear pajamas because of issues. But they're saying
it sounds to me that you need help in, without simplifying it, but it sounds to me that you need more active role in decision making, or you need to be able to help with making decisions. How, you didn't mention, I can't remember, sorry, you might have mentioned what your son was. 25.
He's 25, but it's not so much about making the decisions for him, because we've been allowed, there's no issues. Oh, you can't decide this, that, and the other. It's about how best to ensure the provider actually does agree what also the social workers are saying are fair, reasonable, relevant, and all the rest of it. We're not trying to get something for nothing for him, but these are all it's a bit like, it's different with the supported living, because you go into the MIG and DRE arena, which we've sort of avoided so far, but we're going to have to look at that as well. So it's is there some kind of something we don't want to be sort of quoting the law at them every 5 minutes, which we seem to be having to do, but is there any easy way of making them sort of see sense and agree what we're trying to do? Because what's happened is there's been so many delays because they're sort of arguing the toss about this, that, and the other, and they're all wrong. They are actually wrong. Putting a bath chair in, for example, for him, that was in the brief. He needed the bath chair. Oh, who's going to pay for that? We can't afford it. We're not. If I
can jump in, I think what you need is more legal opinion as opposed to financial advice opinion. So
sorry.
I have no, it's fine. I have some thoughts. So again, if you want to pop me an email via this forum, and I can certainly give you some ideas on that.
Okay, thank you very much.
Welcome.
Is anybody else got their hand up before I go back to the chat?
Just a question about deputyship and LPA. So my son's still, he's only 11, but we're obviously thinking about all these sort of things. He doesn't understand numbers and all this sort of stuff. So, but he has very little capacity. Would it be advisable for an LPA? But then who makes the decision in terms of, has he got capacity to understand that? To go into a deputyship, which means that he may be looked at every year or whatever it is, where it's not going to change. I can see us doing this for the rest of his life.
Yeah, so initially it would be you that decides which route that you're going to go down. You can go and pay for a mental capacity assessment when you get nearer to the time, absolutely, if you wanted to, but initially it would be you. And my counsel to you, or not counsel, my thoughts would be, I would start, if I were in your shoes, with the least restrictive option. And if I thought that there was an opportunity that with help I could help him make decisions, I would pursue the lasting power of attorney route personally, because remembering back to the mental capacity, we have to assume capacity. So I would start with that route. If I was completely lost and thinking, I don't feel that I am able to make a decision on whether he has mental capacity, then I would be using one of those, either a service provider. So you can, and again, I can put that in the resource pack. There are mental capacity assessors out there that would happily help you. Your solicitor would be really good to help you assess that nearer the time. But if it's on a knife edge between the two, personally, I would start looking at lasting power of attorney.
Thank you.
Yeah.
Wanda, do you want to ask your question?
Thank you. I'm ever so sorry. I'm so new to all of this Zoom and I don't know how to hold my hand up or anything. So apologies if I've spoke out beforehand. My questions are, first of all, is, it's very, very daunting and worrying that sometimes you put your head in the sand and think, I'll do a will another time. I'll get it done in the future, But it is so important to get it done as soon as possible because no one knows what's around the corner. So is this just information based, or are you actually a solicitor, and are you able to facilitate this, or do you know places that are very good in that area?
Yeah, that's a really good question. So I'm a chartered financial advisor, I'm a special needs financial planner, so I'm not a solicitor. So the courses that I run are information based. So they give parents information to enable them to make decisions. In the wills and trust course, if you are foggy about what you need to do wills and trusts wise, that would be really good for you to have a look at that. I can recommend solicitors that I've worked with, and I'm more than happy to do that. But I don't, yeah, I don't write wills myself. I talk about my own experiences, and I can talk through how they work and the differences between different trusts, for example, which I quite often get asked, but I wouldn't do that myself for you. I could certainly point you in the right direction, or I can give you some guidance as well as to what.
Yeah, that would be great, because my home, basically my son, I feel, doesn't have capacity. We haven't really gone into it at the moment, but I feel he's 16. I don't feel he has capacity, but he does know he knows his likes and wants, but yet capacity is it's such a fine line, isn't it? In decision making, because I would not, as a parent, want to take away his capacity to be able to make decisions. And I think only a mum would do that. So when you're giving it over to somebody in stage 2, I think it's very worrisome. Who do you sort of put on? So we've changed our loft into an actual flat for him. So we want independent living, for him to have some independent living within our home, but we don't know how that works, because most of funding, and every time I go to speak to anyone, a care package only comes if they're going to be, quote, living independently outside of the home. But he has expressed that he doesn't want to live outside the home. He wants to live in his home, in his bedroom, because he has a whole flat up there, so it's self-contained.
I think sort of just to go back to the point that you made about wills, I'm sorry to bring it back to wills. It's a really important point that you make, because regardless of whether there is the mental capacity or not, it doesn't really matter. If you feel that there is going to be vulnerability, with any kind of vulnerability with regard to understanding body language or anything like that would make that person susceptible to some kind of financial problem, then you would want to consider changing your will to put in place protection. It doesn't really, it's any kind of vulnerability you can protect against that, or you can protect around that using your will, whether there is or isn't capacity there. It doesn't really matter. So the point I'm trying to make is that even if you thought he does absolutely have capacity, even if you thought he's going to go on and live this wonderful independent life, if there was a shadow of doubt that you thought, you know what, but I do think there'll be a slight vulnerability there. I don't think he'll understand if someone said to him, I'll take that from you, let me control that for you. There would be a problem. Then you can protect against that, regardless of whether there's the mental capacity or not.
You've made up my mind for me. Thank you so much.
I think it's so important, and
because it would only take a signature and the house would be gone.
This is the issue, and I think with the wills and trust, it's hugely important, because we can use a will to protect against so many different things. But for me, it's that vulnerability, and I would have exactly the same with Tristan. I can tell you that there is no doubt in my mind, if mum and dad died on a Monday and Tristan inherited on a Tuesday and he had 50 new friends on a Wednesday, there is nothing to stop him giving that money away. It wouldn't even compute. So that's what I'm protecting against in my will. I know we've gone off topic a little bit, but what I want to say is, don't think that because there's the mental capacity there, if there is vulnerability, the will is really very, very important. Very important.
Thank you so much for that.
We'll take one final question and then we'll have to wrap up this session. And that was from Emily, if you still want to ask your question.
Yeah, I was the one who asked about the universal credit and things, because I've got 2 children, both with needs, but I had to give up work because my youngest was out of school. So I'm reliant on benefits. My older son, he's 17, coming up on 18, and it's just occurred to me, I have no idea how this is going to impact on the family finances, him becoming an adult. He gets PIP, he's got an EHC, he's currently in education. We're looking at a special needs college for when he finishes this year. So he's going to stay on in education. But how is that going to impact the family? Because there's going to be another adult in the house in January.
There is going to be another adult in the house. So we know that PIP is not means tested, so he can continue to, yeah, absolutely. And then everything that he claims is for when he goes through and claims benefits, it is based on his own assessment of his own finances. Just like with yours, it's based on the assessment of your own finances. So a difficult conversation to have online, and I'm more than happy to take it offline because I don't want to get too personal, but but it will be based on his finances and yours will be based on your finances now that he's turned 18. So if you want to pick up the phone to me and we can have a chat about that, that's absolutely
Okay.
rather than going through sort of online and sharing it with everybody. But yeah.
Oh, that would be great. So I could ring you up then. Okay. All right, thank you very much.
Okay, it's a really simple query, but probably let's not share it online. We'll do it privately.
Okay, thank you very much. I do appreciate it.
Just pleasure. Absolute pleasure. I hope that was useful, everybody, and informative and not scary. And I am more than happy to follow up with individual care forums. I live in Somerset, so I'm more than happy to travel to the neighbouring counties and run sessions or do virtual sessions further afield, if that is of interest. Thank you so much for attending today. Thank you for your questions and for your interest. Do you want me shall I sign off, Cindy? Are you happy for me to close?
I was just going to add, Rhiannon, a huge thank you to you for today's session. It's been hugely informative and I'm sure it will have helped a lot of people start to think about the future. A huge thanks, Rhiannon. Much appreciated.
Absolute pleasure. Thank you, everybody. Have a nice afternoon.